Under the heading of "It's Not Over Until It's Over," the United States Supreme Court has vacated the decision by the Fourth Circuit Court of Appeals, ordering the appellate court to hear arguments on the constitutionality of two key provisions of the Affordable Care Act. The two issues, which could lead to yet another SCOTUS review sometime during the 2013 to 2014 court session, involve a challenge to the employer mandate requiring that employers with 50 or more full-time employees provide health insurance to its workers or pay a fine, and the contraception mandate requiring that healthcare benefits include a contraceptive benefit without the need for a copay. The court's ruling was in response to a request by Liberty University, the Christian educational institution founded by Reverend Jerry Falwell, to force the Fourth Circuit to give the university its day in court after the Fourth Circuit dismissed the action last year, refusing to hear substantive claims and arguments in support of Liberty's position. The Fourth Circuit's reasoning for tossing the case was grounded in the Anti-Injunction Act, the tax law that requires that a tax actually be paid before a challenge can take place. While this was one of the issues raised in this year's challenge to Obamacare before the Supreme Court, SCOTUS quickly disposed of this as an issue that would have prevented the case from moving forward, thereby allowing the Supremes to get into the more substantive issues. Liberty's employer mandate claim is based on the argument that Congress overstepped its constitutional boundaries with respect to this provision of Obamacare. The university additionally is arguing that requiring it to provide the contraceptive benefit violates its right to freely exercise religion. Interestingly, the Obama administration chose not to challenge the effort by Liberty to get the case before the Fourth Circuit, noting that the issues raised by the university had not been adjudicated by the Supreme Court in its landmark decision. However, the administration's lack of concern might have more to do with the fact that the Fourth Circuit is one of the most liberal appellate courts in the nation and has sent signals during the initial action that they would be more likely than not to side with the Obama administration on the issues raised by Liberty had they decided to actually hear the case. Were Liberty to succeed in its lawsuit, a major part of the Affordable Care Act, the employer mandate, could be cut from the law. Further, the controversial requirement involving contraception would be placed in doubt. While a victory by Liberty is unlikely at the appellate level, the loss by Liberty and its co-appellants would likely bring the request that the U.S. Supreme Court take up the matter during next year's session. While many legal scholars expect that SCOTUS would be reluctant to jump back into the Obamacare frame, particularly given the fact that the law would be in full effect by the time the court would likely get to the matter late in the 2013 to 2014 session, the decision to hear the matter would present Chief Justice John Roberts with an opportunity to square his credentials with conservatives who have yet to forgive his initial Obamacare ruling.